Order. Certainly is nice to be able to follow the Rules Committee because we sometimes take ourselves too seriously here at the Capitol, though I know we're doing the people's work. We always need to keep things in perspective. And having said that, Senator Hatchett, if you wouldn't mind bringing us to prayer, please.
Thank you, Mr. Chairman. Let us pray. Dear Heavenly Father, we come to you at the end of a long day. We know we got a lot of work left to do. We just ask for your continued guidance, and as the chairman said, to continue to keep things in perspective. We ask that you watch over the families of our constituents, our families, and just continue to guide us and protect us. In Jesus' name I pray. Amen.
Thank you, Senator Hatchett. Appreciate those words. We have 5 bills today, and let me just say up front that we have time tomorrow, which I do not want to take up. So I'm going to ask people to be brief and concise, but to the point, and let's keep this moving. I apologize to Chairman Setzler. I had told him he was going to go first, but Chairman Powell has been very good to us. Not that Chairman Setzler has not been good to us, but Chairman Powell, you are going to go first, and we have a substitute. So we're going with House Bill 369, and so if everybody would, that's the second bill in your folder, and we're on a substitute LC 338810S, and the floor is yours.
Thank you so much. Always glad to be here, and even more, thank you for the courtesy allowing me to go first today, because I know y'all have a long day, and I'm going to be very brief. House Bill 369, and I don't have a copy of if y'all have a substitute or committee sub, but I'll go from the bill that passed the House.
Let's give you the committee sub if we can. Lawson's bringing it to you, and we appreciate that. Appreciate your cooperation and working with us.
All right. And I'll speak briefly from the original, and then I'll get a chance to look through this because y'all will already know the changes that y'all made.
If you would like for me to, I could update people if that would be good.
Please.
I apologize. We have talked about this, and I know you've been in agreement, but I just want to, for conciseness' sake today, if you will, the changes, if you'll look on pages, on page 7, in that section, and we're going to have an amendment on that particular section to clarify so section reading on line 155, and shall only include Schedule 2 controlled substances included in the code section 161326 if authorized pursuant to subsection D1 of this code section. And if you look over at subsection D1, that is referenced on line 176. And what this does, it limits advanced practice registered nurses with 2 years of experience may prescribe hydrocodone in emergency situations, and there are exclusions there. And it does the same thing for PAs. So what we did was we tightened this legislation down from all of Schedule 2 drugs down to just one schedule drug, which would be hydrocodone. And the logic is that the other Schedule 2 drugs are not necessary in emergent situations, and those are drugs that are more potent narcotics and are drugs like amphetamine-like drugs like Adderall or Vyvanse and things like that. And there's really no emergency relating to those particular drugs. So that's why we tightened that language. We had passed this out of the Senate, the House, and then the Senate in the past too. Now, it did get vetoed by Governor Deal in 2017. But what we did was we tightened that up and allowed 2 years of experience with the hydrocodone, and we limited that, and we made that for notification of their supervising physician. Chairman, is that any comment on that or thoughts on that?
It's the only thing I can say is better than what's current law.
It is, that is an
Certainly is.
advancement. Now,
And,
for clarifying sake, I'm going to call on Senator Kirkpatrick for the amendment okay, different bill. Sorry, apologize. I got that. You do have a question. All right, why don't you go ahead and do the question while I get the amendment. There we go. Okay.
Yeah, just on line 182, it says initial prescription. And that would imply that there's more
So
than
that,
one?
I'm gonna, yes, so that is part of the amendment. So let me go ahead and do that.
Okay.
And the amendment that I have is on line 155, and we're going to keep the or any, so section, it's going to read like this, section 161325, or any Schedule II controlled substances include in Code Section 161326, except as authorized pursuant to subsection D1 of this code section. So that's the way it's going to read, and I have for Mr. Beal the changes here. And then we're going to have the other changes in 182 will be 182, prescription drug order is limited to, and we're going to change the word "a," and then instead of initial, it's going to be single. So it's going to read, the prescription drug order is limited to a single prescription not to exceed a 3-day supply. And there will be no subsequent prescription, so lines 187 through 189 will be deleted. And that will also happen on lines 270, where it will be the same thing. The drug order is limited to a single prescription, and then 275 through 277 will be struck. So the logic on that was, in emergency situations, there will be a single prescription, but no subsequent prescriptions. In other words, you won't continuously do that. And the logic and the thought process is that during the pandemic, there have been an increased number of mental health issues, increased number of substance abuse cases, and increased number of suicides. So we want to be cognizant of that and not trying to make a problem worse. And that's why that was vetoed back in 2017. Any questions at all? Senator Orrock.
Thank you, Mr. Chair. Now, we're going very rapidly, so.
Yeah, you're right.
So pardon me if I'm
Certainly.
overlooking something, but you said this included physician assistants as well?
Yeah, it's two sections.
I see, the first is the mass practice nurses, the second, and are those two professions in agreement with this? Or
Yes.
do they really have any choice in that?
Well, they are, as the chairman alluded to, this is more than they're prescribing now, and this is a carve-out for that. Yes. So, if there are no further questions, I will, Senator Burke.
369 as amended by committee substitute.
Okay, we'll get, so we got a do pass, but and we're going to do an amendment. So we'll,
Work on the amendment first.
yes, let's do the amendments as I outlined. And if we can, I'll take a motion for the amendment.
Do pass.
Do pass for the
as you
amendment.
enunciated.
Second, Senator Kirkpatrick. All those in favor of House Bill 369, I'm sorry, we're doing the amendments. All those in favor of this amendment, please say yes.
Yeah.
All those against, like sign. Okay, that's unanimous. And then, so now I'll entertain a motion for do pass for House Bill 367 as amended. I'm sorry, as substitute. House Bill 369. I'm sorry. House Bill 369 substituted. So moved.
Second.
Second, Senator Burke. All those in favor say aye.
Aye.
All those opposed, like sign. Passes unanimously.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee.
Yes.
Always a pleasure to be with y'all.
Okay. Thank you. Did she abstain? I mean, she said no. Okay. I'm sorry. Senator Al, we recorded your no vote, and we appreciate that. Thank you. And Senator Butler, too, was that right? Okay, so 2 no votes. Thank you. Okay. Okay, so you clear on the... All right, we are moving to what was, I had initially told Chairman Setzler that we were going to go first, so he's our second first. Chairman Setzler, I apologize. I appreciate that. I know you've done a lot of work on this, and we appreciate all the work that you've done. If you would, my posture is going to be, you will present the bill, and then we're going to have some testimony, and then we're going to have probably some amendments or substitutions or things like that, and we'll let the committee, the will of the committee, we'll discuss that, and we're going to take a vote, and then we'll go from there. So the floor is yours. Thank you for your work.
Thank you, Mr. Chairman, members of the committee. It's a pleasure to bring before you today House Bill 290. In spite of the fact that the tens of thousands of emails that have flowed into us around an issue relating to access to family members during times of emergency, this bill has nothing to do with visitation. This bill has absolutely nothing to do with visitation. In fact, if you look at lines 150 to 160 of the bill, this bill gives hospitals and long-term care facilities absolute, complete control of their visitation policies. Absolute, complete control of their visitation policies. What this bill does, Mr. Chairman and members of the committee, this bill simply does one thing. This bill recognizes the role of legal representatives, next of kin. The legal representative that stands in the place of other people in the place of and beside patients to make decisions for and with them. It gives them access to make that decision even in times of emergency. So I'll start by saying this bill does nothing to do whatsoever with visitation. Now, I know as members of this committee that's been lobbied and talked to about this issue, that those issues of the legal patient representative and the visitors have been conflated, in some cases mistakenly, other cases perhaps intentionally. But as you start on the second page of the bill, after we get through the definitions, legal representative, essential caregiver, and visitors are defined separately, and hospitals and long-term care facilities are directed to draw distinct policies for these because they have their own separate code sections. They're not even, they're only comparable in the sense this bill deals with all of these. And this bill, again, gives absolute, complete control for setting visitation policies to hospitals, long-term care facilities. The issue of essential caregivers is set aside only in the long-term care setting. That's where sitters, support persons who can sit with people over periods of time are contemplated, but they're nowhere in this bill considered in a hospital setting. The crux of this bill, Mr. Chairman and members of this committee, is this issue of the legal representative. Now, in your packet, you have a reference to 42 CFR 48213 and 4210, which are the CMS standards by which long-term care facilities, and I think more importantly, hospital facilities, are regulated by the federal government. And as you can see in subsection A, the patient's representative as allowed by state law. State law is the place that the role of the legal representative is defined under a whole federal framework. Because the federal government recognizes that agency, powers of attorney, those issues of stand-ins are specifically prescribed to states. Civil practice, medical practice, nursing practice is all specifically a state thing, and CMS prescribes that's exactly where those decisions shall be made. So what we're doing here is in no way out of step. In fact, on the 22nd of February this year, Mr. Chairman, myself, the House Committee Chairman, and my co-sponsor, Dr. Mark Newton did a conference call with our Department of Community Health and confirmed that this bill is 100% compliant, 100% compliant with all CMS requirements and all federal requirements that affect long-term care facilities and hospitals, because we fit it right in exactly to the prescribed place where it's supposed to go. What this bill is about is about the role of that legal representative in standing beside patients as they make life-changing decisions. That's what this bill is about, in spite of what you might have heard. When you think about it, Mr. Chairman, under our law, 16-year-olds that are in hospitals facing life-changing medical decisions have their parent or their next of kin standing beside them to make that decision. Unfortunately, under emergency circumstances, 19-year-olds are left alone. They stand by themselves in a hospital. They do not have access to somebody in an emergency setting like we've seen for the last year, because they're an adult, they've reached the age of majority, and they are rendered by themselves. They're given a chance to maybe see a family member through a FaceTime experience. But 19-year-olds, 39-year-olds, and 89-year-olds have no access under emergency circumstances we've seen in the last year. They stand alone, they're isolated from having that key decision maker anytime to have access to be close to them and proximity to them to help make decisions that are medically appropriate, standing beside the care team. Mr. Chairman, I won't spend more time than we need to, but I do want to highlight an important point, that what this bill does, what House Bill 290 does, again, not touching visitation in any way other than to say hospitals definitively have the power to set their own visitation policies. This bill does an essential thing that only the legislature can speak to. It creates this balancing test. It creates this reconciliation of emergency powers and the basic rights of a patient to have assistance in making decisions. Okay. Emergency powers prescribe conditions in hospitals. But the role of agency, the role of this legal representative, how that interacts and how those things weigh against each other is exactly what this bill does. It seeks to fit those things together in the least burdensome, most careful, most deferent way possible to the care team, to hospitals, while still effectuating the fact that the legal representative is not a visitor. They're the decision maker, standing beside the doctor only in the importance in care decisions that are being made. That's what HB 290 is all about. And every provision of this effectuates and fleshes out how these two vital interests, emergency powers of the governor and the core decision maker making the decision next to the doctor as part of the care team, how that plays out in the context of emergency circumstances. Mr. Chairman, as we go through the bill, I'll just kind of highlight the sections. The first section, of course, is definitions, then policies. Beginning on line 60, Code Section 317432 is the legal representative. And that's really the crux of this bill.
Are we working from the same thing that's in our folder?
We should be on LC 338808 ERS.
Yes, ma'am. That's right. So, Mr. Chairman, the bill attempts to do one vitally important but very sensitive thing that represents the lightest touch possible. How can we have the lightest touch possible in a critical care or an acute care setting to make sure that essential decision maker has access to physical access under time, manner, place restrictions completely set by the hospital, completely tailored to the setting that's appropriate. What this bill does is it recognizes after 12 hours in a hospital, decisions are being made. This doesn't give a legal representative the right to follow an ambulance to the hospital and impose their way in. None of that's present here. None of that. What this bill does is after 12 hours, it gives a patient the right to say, you know what, I want to have a person stand next to me to make the life-changing decisions that I'm facing, isolated here all by myself. And in doing that, it creates has a couple protections. One thing I would direct everybody's attention to is line 84 and 85 on page 4. It says hospitals and long-term care facilities shall not be prevented from imposing reasonable, again, the reasonable standards, the coin of the realm in civil legal practice, safety requirements specific to each clinical and residential setting to effectuate the in-person physical contact. So what we do here is we're saying hospitals have absolute flexibility to establish time, manner, place, conditions for this 1 hour of access. What that means is hospitals can require that you take a PCR test. They can require that you wear a mask. They can require in certain settings you wear full body garb perhaps and a shield, or even stand behind perhaps some kind of, in the most acute settings, some kind of screen as you're standing 3 feet away from your family member, but you have physical presence there as opposed to being consigned to making these critical life-changing decisions through the screen of a 5-inch iPhone, through FaceTime. That's what this deems to be unacceptable in making these critical decisions. And for 1 hour a day, prescribed in time, manner, place by the hospital or the long-term care facility. That's what this bill does. It clarifies some things, that the cost of any kind of PPE or protective equipment is not going to be borne by the facility. It's borne by the legal representative, or could be picked up by insurance, as the case may be. And puts in place a structure that says the patient doesn't have a right to sue. Something that's changing the Senate substitute that at the request of many of the senators around this table, at the request of others, is this sense of a right of action. We've reduced that on line 101 to 103 to injunctive relief, that a patient could bring action to enforce the provisions of this, but not bring a traditional civil suit for damages, for any form of damages or injury arising from this code section. Mr. Chairman, that's what the bill does. Glad to answer questions. I'd love to go through line by line, but I'm not sure the committee wants to stand for that. So.
All right, questions? Senator Kirkpatrick.
I have a few questions, if it's okay. You and I have already talked about some of this, but the
ma'am.
committee wasn't party to the conversation. So, first of all, about the definition of legal representative, I just want to be sure I'm clear, because when people check into the hospital, they've got an advance directive. Sometimes they have a durable power of attorney, sometimes they don't. I think that you're referring back to the consent statute, 319-2
Yes, ma'am.
is where that came from.
Yes, ma'am.
But I just wondered if you could clarify how that all fits together.
Great question. I thank the senator for that. One thing we're doing is we're looking to nest this in the existing Georgia law. That's what you're referring to is a very robust, well fleshed out framework within Georgia law. That patient makes decisions for themselves. The next decision maker is their durable power of attorney, or their person that's got the advance directive. That's number 2. That even outranks their spouse if it's so directed. And then there's a whole pecking order beneath that. This bill adopts that as it stands today. The effect of that would be if someone presents in the hospital and they're unconscious, that framework would absolutely control who this legal representative can be. It can only be the person that's designated. It can't be someone else. If, however, the person was of sound mind and they presented in the hospital, and their next of kin or the person that's designated with that power of attorney, for example, we're in Kentucky, they could designate perhaps an adult family member here for a season of time until maybe they could get into the state and help make those decisions. So that's exactly how the framework works today. Person with consent can make those changes in person should they choose to, but our goal is to not change that at all because that's well established under Georgia law.
Mr. Chairman, if you don't mind, I have 2 more questions. Lines 84 to 88 you referred to that give hospitals and long-term care facilities the ability to impose reasonable safety requirements. And I'm just wondering if that gives flexibility to contemplate things like crime victims, inpatient psychiatric units,
Yes.
and other places where are a little bit different than your acute care hospital.
Thank you for the question again. We've got listed above that begins to touch on the issue of the criminal setting. If someone comes in and they're under the custody of law enforcement, there's an officer in the room with them, for example, their ability to get a legal representative there is voided because they're under state custody. They wouldn't otherwise have that right. But in the case of people that the representative might be under suspicion, we actually had that in the House bill. Early in the House version, we had that, and people came to us and said, you know what, I'm not sure that the facilities and others came to us and said, we don't really want to have to make these kinds of decisions about is this person a suspect, is it risen to probable cause. The patient, if they're uncomfortable with the person being there, can quietly whisper to a nurse, I want them gone, and they're gone. The hospital already has that power, and the patient has that power. So that was carefully contemplated, even written into an early version and taken out specifically because we felt like the powers existed to get those folks out of the situation as it stands today. To your second part of your question, Senator, about in the psychiatric care units where folks are in maybe a violent episode, they're in a padded room or something like that. You think about this reasonable standard. I don't know that any of the physicians here would order a family member to go in there and deem that reasonable. What we are recognizing, though, if you have a family member in this setting, that being able to look at them through the glass of the door, be able to observe what you're seeing personally as opposed to a phone, that setting we believe is appropriate, and that's within this framework of this reasonable standard for protection. And those are the kind of decisions we want to be made singularly by the hospitals and the clinicians. We don't believe we could, the diversity of circumstances is so broad, we could never solve that under the gold dome other than giving them the full time, manner, and place powers to make those decisions.
Okay, one more, Mr. Chair. On line 127, you talk about, I think this is a completely different situation for long-term care, but here it provides for 2 such legal representatives or essential caregivers for 2 hours. Can you explain why that's different?
Yeah. There was an understanding as we took testimony in the House and got feedback that a long-term care setting is different than an acute care setting. You know, we initially started with this idea that acute care perhaps ought to be 2 hours a day, and we really narrowed it down. We realized, what is the real interest here? The interest in the acute care setting is not one of visitation or observation, it's one of decision-making. I mean, it's a decision-making hour that you can observe somebody, perhaps the doctor's making the rounds, you can make the decisions in that hour. In this setting, because it's more elongated, it's over time, that 2 people, it could be the representative or an essential caregiver, would have 2 hours a day, time, manner, place determined by the long-term care facility. And the Long-Term Care Association supports this. They think that's an appropriate, balance. It could be in the day room. My son works in a long-term care facility. This visitation happens in a separate day room. People aren't allowed back into the ward because, again, the facility determines time, manner, place, and where that interaction can happen. And we believe that was the more appropriate balance. I would say for members, the long-term care setting is still subject to a governor's emergency order. So these essential caregivers, more sitter types, they can still be prohibited from access by the governor. It's only that legal decision maker that the person has an absolute right to, even in an emergency circumstance.
Thank you.
Any other questions? Got 2. Senator Al, number 12. Okay.
Yes.
Hi, how are you?
Senator.
One quick question. You had framed this as not a visitation issue, rather an issue of the legal representative helping to guide healthcare decisions
Yes,
for a
ma'am.
patient. Can you explain why a legal representative needs to be physically in person to help guide these decisions? And I say this as someone who has many, many, many times in her career had to make these sort of critical, emergent decisions for a patient with the legal representative not there for a number of reasons. Decision-making, I'm confused why physicality is required for that type of assessment.
Well, I think it's a circumstance. I think you would recognize that having a family member on the telephone or not present, if there's a circumstance where someone presents that's not been under observation for a long period of time, a family member being able to look at them and determine, is their color right? Do they look normal? How do they normally look? I mean, as a clinician, someone presented and you had 30 minutes with them, you don't have the context of what they normally look like, how they hold, how they speak, those kinds of things. This belief is that there's so many important decisions being made that we sub-optimize all the time and have to sort of get by with things. But when you've got life-changing decisions that are being made and you've got employees of the facility having broad access to the facility, it's a false premise that W-2 employees should have access throughout the facility, but family members can't. For example, my son is a 22-year-old college sophomore working his way through school. He works in a facility. He has access to every single room in the facility. He's no special kid. But if your mom or dad or family member was in that same facility, they'd turn you away. As a 30-year physician, 35 plus, however many year physician you are, in your experience, you'd be turned away as sort of an extraneous visitor in the minds of some, but my son would have full access to the facility because he's a W-2 employee.
Okay, all right.
There's a fault. Yeah,
Might be a little misleading there. I doubt your son has unfettered. I mean, he can go into the lockdown units or mental health units or the OBGYN where they're delivering a baby. Okay, all right. Next
The
question,
only point
follow
I'm
up
making,
there.
Mr. Chairman, is that
Gotcha.
there are employees who are important in the delivery.
Yeah, I mean, I don't have unfettered access everywhere, and I'm a physician, so, I mean, that's No,
Okay.
don't go there.
So I misspoke in the sense of unfettered access, but it has broad access. People who
Right.
clean rooms, deliver meals, have access to patients. But just because of the status of a non-W-2 employee, it's a false premise that you're dangerous, but because they're a technician working in the hospital, they're all of a sudden safe. I think those same conditions, if the hospital says you're held to the same standard that a technician cleaning bedpans or delivering meals will be held to, there's no reason that that can't be made safe.
Just one more question.
Thank you, Mr. Chairman.
And then just to follow up, there is also the premise that the patient could be dangerous also to the public. One follow-up question is this premise that patients or people are left alone when these emergency conditions with the EO, the emergency orders being enacted. Isn't it true that already that hospitals and certain healthcare facilities practice medical discretion in letting in certain types of visitors and companions under critical circumstances or with certain conditions like language access, end-of-life care, dementia, these types of things, that these types of permissions are already given on a case-by-case basis, balancing the need for public health and safety?
Absolutely. That's proof. Your point is proof positive why this is possible. The fact that people are brought into hospitals in end-of-life circumstances or in a compassionate care setting or perhaps at the hospital's discretion to make decisions is proof positive there's a process that hospitals can use to accept representatives in and be able to do it in a safe way. Because it's happening, it's proof positive that's able to be done by virtue of the patient's right. If it's happening some at the hospital's discretion, why can't it be a patient's right to have it? Because to your point, it's being done consistently now. It just ought to be a right to every patient because those procedures do exist.
Well, I think the discretion and the consistency are two different things, but thank you. Appreciate that.
I'm number 11 here. Hopefully these will be quick. You talked about the governor. On line 97, when it says the governor shall not be authorized to waive or otherwise limit, you're saying that the governor doesn't have any emergency power over the legal representative, but has power over the others? Is that what you're saying?
Yes, Senator. What I'm saying is, I want to be very, very clear, is that the visitors, hospitals, and long-term care facilities decide. The central caregivers, the support persons, governor has control to completely lock them out.
Okay,
In the case of these legal representatives who are making decisions, even under emergency orders, they have access to 1 hour per day. That's the lightest touch we believe is essential to effectuate this decision-making.
Okay, so the governor has no emergency powers there. And then on lines 104 through 108, and maybe this is a question for the lawyers too, but how is that different than current law?
Yes, sir. The structure in 104 through 111 is the special heightened COVID framework for liability. The framework we put in place to protect businesses and facilities during coronavirus, we created a standard that to have any liability, there's got to be willful or wanton misconduct, reckless infliction, intentional, or gross negligence.
So outside of COVID, what is the standard?
The standard's one of simple negligence. This
hospitals.
provides a much higher bar to clear to be able to bring a lawsuit against a facility. And this, candidly, to the Senator's point, creates a level of protection for hospitals and long-term care facilities with respect to their visitation policies it carries forward. So that in this balance, this creates a pretty good protection consistent with what's being done in coronavirus carrying forward to again, provide some protection to our facilities to implement this.
So the law will stay the same as it is right now for the next year or whenever that current COVID liability, this is the same thing, so it's
Yes, sir.
really no difference in the law. Okay.
It actually would carry, when things go back to normal, as it were, this would carry forward. Yes, sir.
Any other questions? Senator Walker.
Thank you, Mr. Chairman. I want to go back, Representative Setzler, to I guess the definition of legal representative and get you to explain to me how, if let's say you have a patient or family member that's got a durable power of attorney already in place, does this legal representative supplant that? Are they in addition to that? And what if the two are in conflict?
They are that. That's why we drafted, to Senator Kirkpatrick's question, we reference 31-9-2 to make it very clear it's the same person, period. This bill doesn't change that framework at all, and our goal was to make sure we did nothing to change that framework, because it's so well established, there's no reason to change it under this. We're referencing that to say, the framework that exists today, we're using that, we're adopting this into this bill, and nothing changes.
Okay. Can I follow up on that, Mr. Chairman?
Yes.
If they do not have a durable power of attorney and let's say they have dementia and they decide to, and they have a living spouse or an adult child that would kind of be the logical caretaker or legal representative, but if for some reason in their confused state, they just designate some arbitrary person, I mean, is that a concern of yours, or how would that be addressed?
You know, that exact same condition exists today. You know, physicians, in fact, when you read the State Operations Manual, CMS has a publication 106, Appendix A, State Ops Manual. It goes through a bunch of what-ifs and kind of walks through how clinicians make these determinations, but it's fleshed out. I think clinicians here would tell you they've faced those things before. This bill in no way changes that. There would be a determination as the person of sound mind to make that determination. And 31-9-2 puts a pecking order in place that says the patient, durable power of attorney, all advanced directives, next spouse, then adult child, then sibling. There's a whole pecking order that 31-9-2 gives us. They would follow that same, if there is any dispute, they'd follow that prescription that's laid out in 31-9-2.
Okay. Thank you.
Yes, sir.
Senator Hatchett.
Thank you. My question is also with the legal representative. If the legal representative, is this a fluid representative, or is it once they designate the legal representative, are they allowed to change it? Can I have one legal representative in the morning and then go, I think I want a different legal representative in the afternoon? I mean, it just,
Sure.
Could you clarify that?
Well, let me start by saying, and I have in your packages these 42 CFR provisions. The term legal representative comes right out of 42 CFR 4213 because we're patients representatives and then resident representatives because this is intended to be nested right in federal law. You know, when you think about that, is a 31-9-2 doesn't take away a patient's ability to change and say, this person's not speaking for me, now this person is. So we're not looking to change that. I think if you what-ifed an erratic set of decisions, that things are changing on the medical staff at all times, I think a physician could say, hey, listen, I've heard you say this. This person's going to be the legal representative until I believe there's a material change in this to recognize it otherwise. Some of those issues are talked about even when there's conflicts. That's laid out in the State Operations Manual. We did prescribe down below I'll find the spot lower down in the bill, where we give in the rulemaking, Department of Community Health will prescribe rules for this. We give them that rulemaking power. I would anticipate in that rulemaking, they'd set a framework for that. In fact, we prescribe specifically in the long-term care setting, they shall determine the process for changing or assigning essential caregivers. We didn't want to make that apply to legal representatives because that's so fleshed out in 31-9-2. But that's within the rulemaking power. If there's issues about on again, off again, we believe that can be handled by the DCH as they write the rules. I didn't want to overprescribe. And with respect to legal representatives, I didn't want to write anything that colored or cast a shadow on 31-9-2 as it exists today. I'm trying to stay out of that because that's no different than what would exist today if someone was changing their designation of that. So.
All right, so it looks like we've exhausted the questions from that, so we will, I'm sorry, I apologize, Senator Kennedy.
It's all right. Thank you, Mr. Chairman. Just a couple of questions. Representative, forgive me if I'm, probably should know this, but the first part of the section, of the bill, on page 3, we talk about access for 1 hour per day. And then we get over to page 6, and I think maybe the distinction is when we're talking about long-term care facilities, then we go to a standard where it's
2.
2 hours per day.
Yes, sir.
Just help me understand the distinction and why the difference there, please.
When we started this process, we were thinking 2 hours per day as a minimum. And then we recognized as we really boiled down to this issue, and you started to see the separation of these different characteristics. Long-term care is different than acute care. And the belief was from a long-term care, it's more of a visitation, more of a checking in on someone. Acute care is you're making decisions, is a decision-making time. And did we need 2 hours to be there to make decisions? And because it's centered on decision-making, we believed, again, trying to have the lightest touch we possibly could, we could reduce that to 1 hour. And it also recognizes an acute care setting is different. And we wanted the lightest touch we could bring. And we felt like that 1 hour was enough to make important decisions. That's the difference.
So it's just the setting?
It's the setting. Acute
Okay.
care versus long-term care.
Okay. One other question, Mr.
Sure.
Chairman? So just a question, Representative, this sort of caught my eye. In looking at the LC number 8808 ERS, as I recall, ERS seems to indicate that the Legislative Council is not endorsing or they've not acknowledging authorship of this bill. Can you help me understand what the process of your bill has been to get to this point? Did this come from Leg Council? Does it have their blessing, or is this the work product of someone outside Legislative Council's office here at the Capitol?
I'm glad to let Ms. Howerton, you can see the LC 33, it's got her number on it. I think there's certainly language that we brought to her as we've tried to negotiate this issue. This is an issue that really exists on a razor's edge, trying to balance these different interests. And as we negotiated with attorneys from hospitals and different care settings, hey, we really need this, we'd like this. We have really tried to be the honest broker, and that's what I appreciate the chair doing as well. It sat me down with attorneys representing interests that are perhaps on the other side of this issue to try to walk that razor's edge. We provided Ledge Council with some language that was negotiated between entities and said, hey, we need this language to try to meet this this balance. So appreciate Ms. Howerton's flexibility, and I wouldn't want to ascribe that specific language is hers because some of it came through these negotiated meetings with groups of attorneys and different interests.
Is it her work product?
LC
Legislative
33?
Council, yes.
First of all, I'll just say that we don't sort of bless any legislation that comes out. We obviously are nonpartisan, and what we're doing is doing a legal review and advisement. ER stands for editorial revisions only, and we have kind of gotten away from that. We don't put that on there very often, but it typically is because either there's a lack of time to do the proper legal review or lack of flexibility from the member to do changes or legal review, that kind of thing. And I can't speak to specifically because that's attorney.
Sure. I didn't want to invade that, so, okay, thank you.
That's just generally.
Okay. Thank you, Mr. Chairman.
But I think to your question, we've, in trying to bring feedback and work on language, we say, hey, Ms. Howerton, this is what we've got from these different interests. We think this meets the razor's edge standard. She's been very flexible within that, but this is not a bill I gave to Betsy to figure out for us. It's been negotiated through about 10 or 11 revisions, and that's how we have what we have.
All right, Senator Hatchett, 4.
Thank you, Mr. Chair. And I'm sorry to keep harping on this legal representative. If I heard you correctly, what this does is basically it doesn't change anything in the way a legal representative is determined now. So it's basically doing the same thing that we already have.
That's correct.
Okay. Can I ask?
We give it the term legal representative because that connects directly with CMS definitions of representative.
So that's a federal term we're bringing into state law. The first time it's ever been in state law, and it is, they do leave significant leeway in defining what legal representative to the states. Is that an accurate statement?
42 CFR says, as defined by state law. It's our job to define it, so we're defining it.
Okay.
These fundamental right, as you look at to make informed decisions, monitor status, that language is lifted out of CMS regs and put here, not by reference, but it's put here, so that we're copying their language exactly, but we're tying it to our existing representative statute in 31-9-2. That's, we're trying to tie those two together as clearly as we can without creating conflict with each other.
Okay, thank you.
Any other questions, Senator O'Rourke?
Yeah, just following up on that, if the author would explain. You said the code section that is referenced. What is that code section?
Code Section 31-9-2, Senator, is the code section that deals with the people who make consent to help you make healthcare decisions.
You're talking about the advanced directives and all the things that a patient can execute?
No, advanced directives are a line in that. But the pecking order from the patient to the person with the advanced directive to the spouse to that whole pecking order of who gets to make decisions for you if you've not designated somebody, that's what 31-9-2 is. People who can make decisions for you if you're not able to. And advanced directives is one line item in that.
All right, we've, the House spent about 4.5 hours on this. I don't plan to spend 4.5 hours, but the pace we're going, we may make that. We have, if there are no further questions, and it doesn't hurt that we can't have more questions as we go along, we have about 15 people that signed up. I had said we're going to limit it to 2 minutes, but we certainly would appreciate it if it's been a long day. And we started off in Judy this morning, judiciary, some of us did, and that was so much fun that we're here today talking some more.
Mr. Chairman,
yes.
there are 2 House members that weren't signed up as
Ms. Rich is signed up.
Okay.
And Dr. Newton is signed up. I will leave it up to you 3 when they want to talk. Ms. Rich is like 6 on the line, and I'll let Dr. Newton choose when he wants to go.
Could he jump in now? And then
Yes, jumping in now is good.
Thank you.
And I won't limit him to 2 minutes, but if
I'll
he
try to be
does go
respectful.
much longer,
I am an ER doctor. We do have to move quickly when we have to and work with great teammates. I so appreciate this committee looking into this bill carefully. I wish you had the opportunity to have seen some of the messages that we've heard from across Georgia, the devastation that's been there. Now, it's been brought by COVID, but it hadn't been limited to the 500,000 Americans that have died. It's also affected so many others, and we're looking at this and saying, isn't there a way we can do just a little better? Isn't there a way we can both be safe while at the same time taking care of people, many of whom, millions of whom have died of other causes, many of them who've died alone. We had a long, as you say, 4.5 hours of listening to that, and that's why I really appreciate Chairman Setzler and being able to work with him. I've spent the entirety of my professional career inside the 4 walls of a hospital, as others in this room have, but so I care deeply about making sure that nothing is going to threaten the certification. That would be the worst thing in the world. First, I assume the governor would veto it too, so we don't want to spend a lot of time coming up with a solution that wouldn't work or wouldn't work for our hospitals. And as Chairman Setzler mentioned, some of the earlier things about 4 hours and 2 hours drew them back down to 60 cumulative minutes. Now we're going to talk just about the legal representative in the hospital situation. That's where I and many others work with great people working to take care of patients. What we've seen in that, we've seen the difficulty making decisions with patients when they don't have anyone who can help them. And the best way to look at this is to imagine, as Chairman Setzler mentioned, about a 14-year-old. All of us understand that it's not perfectly safe to bring 1 or 2 parents in to a facility around staff like me and nurses I work with. It's not perfectly safe to do that, but none of us questions that because we understand a 14-year-old, while they can answer questions, they can probably understand risks and benefits read to them. They need someone there to help them. They don't have the capacity really legally, and that person is a legal representative. We call them the parent most of the time, but it doesn't have to be. It can be another legal representative. So those patients are there. They have the advantage of someone who can have direct access. Another area I think that the chairman was wise about and made careful attempts at, the safety precautions. Those are reasonable safety precautions are defined by the hospital. There was discussion about should we spell them out? Should we spell out the costs and everything else? But the reasonable safety precautions are what they're going to put on me if my child is in the hospital. And the safety precautions for knee surgery might be down here. For a bad flu year, they might be up here. For COVID or Ebola, they might be up here. For transplant services or immunosuppression, they might be something different. But we don't keep the parents out. We don't keep that legal representative of that, I won't say incapacitated, but undercapacitated patient. We don't keep them there without anyone able to both comfort them, to take a look at them briefly, however briefly it is. And that's where I thought that the 60 cumulative minutes decided by the hospital out of 24 hours, as he's mentioned, was a light touch. The ability to insist on reasonable safety precautions, which will vary depending on the pandemic or not, it'll vary based on different things, but the ability to do that, if you can see, if any of you, from a patient point of view, we may hear from a couple of patients today, but when I'm explaining risks and benefits of a potential procedure or surgical procedure to someone, and maybe they're short of breath, maybe they're in pain and sweating, maybe they've had to be sedated a little bit just to get to where we are. When you see a family member that's brought in with them with reasonable safety precautions, and you can just see the calmness that just melts into them, the fear that melts away, because now they know that in spite of all the hundreds of people working in that hospital who care deeply, our hospitals care deeply about everyone in there, including their staff as well as the patients, but now they know there's one person there for however a brief amount of time that has been able to come there and do nothing but represent them. It's like having my own lawyer if I was in a courtroom and all of a sudden I've got one person who only represents me.
I'm not sure I want to go there, but...
No, I went too far.
Okay. All right.
But I can tell you, just when you look, when you see that on a patient's face, you're able to have a substantive discussion with both the patient, who I'm talking to, but they've got somebody right there with them, possibly holding gloved hands with them. They know somebody is there to help them make a decision. I can tell you it's great for us as a provider because they help that patient do that. And that's something I think this bill is carefully crafted to do the lightest touch possible, but to ensure that it meets CMS guidelines. I've spent more time in the Code of Federal Regulations, usually forwarded on from Chairman Setzler, reading the final rules and all the comments and the answers. We've got a lot of work that's been done. This does look like the minimum amount that I think our fellow Georgians, or any of us, if we're sick and incapacitated and need someone there, you don't need to be 3 weeks in the hospital and no one's been in your room, no one knows anything about you, whether you have unexplained bruises, whether you want to go home and maybe get hospice, somebody who can help you make that decision. I think this 60 cumulative minutes a day with reasonable safety precautions is really a minimum that we ought to offer to Georgians. And the good thing about it is they could start this today. Our hospitals could start this today. I heard about a representative friend who got his hospital to change the policy, not just for him and his family, but their entire policy based on who could come in recently, because there's COVID protection liability right now if you want that, if you need that extra protection that this bill wouldn't go into effect, if the Senate so chooses, it wouldn't go into effect until July 1. But there's nothing stopping the hospitals from doing this now. It would not affect their certification. It would bring a compassionate hand-holding to patients who desperately need it, who we got the opportunity to listen to 4 hours of on your behalf, and I hope that you will give it some favorable consideration.
Thank you so much, Dr. Newton. So we have, and if it's okay, Ms. Rich, you're on 6 on the list. We're good with that? Okay. So we're going to do testimony now. Brittany Ellison, and on the batter's deck is Debbie Quatney. So if Ms. Ellison can come forward. Coming in. Ms. Allison, if the podium is yours, and we're going, if you can do 2 minutes or less, that would be great. Tell us who you're with and your thoughts on the bill.
Sure, thank you. I'm Brittany Ellison with Family Policy Alliance of Georgia. My inspiration for working so hard on this bill is one of my friends, Abby, who is a nurse at a local hospital. Before she knew this bill was in the works, she told me something needed to be done. She can't be here today because she's afraid of repercussions, but I have a letter that she had asked me to read. She said, "I apologize that I could not be in attendance this afternoon. I'm currently working down at the hospital in the oncology unit. One of the reasons I wanted to become a nurse was because of the bond that the nurses have with their patients and their families. But I wouldn't have imagined I would be playing the role of both nurse and family. While working on the floor, I have seen the strain of my patients both mentally and emotionally because they are unable to see their loved ones. In my first week on the floor, my patient died alone in his room. He was never able to see his family. It is heartbreaking to see patients fighting for their lives, but unable to have any family fighting alongside them. Cancer is an aggressive disease for patients to endure, and I believe that no one should ever have to fight that alone. I understand the current climate and the risk of COVID, but for some patients, this is the least of their worries. If a patient is near the end of their life and struggling alone, it is inhumane to deny them the ability to have a loved one by their side. No one deserves to die alone in a hospital bed with or without the risk of COVID. I hope we will consider this bill because being together in a time of crisis benefits both the patients and their families. Thank you, Abby. Thank you all for your time.
Thank you for being under 2 minutes, too. Thank you so much. Debbie Quatney. And then in the on-deck circle is Mike Griffin. Yes.
The letters that we've gotten reference a different ERS number, and I'm just wondering, the people that are testifying, are they referring to the previous version or the current version that we have it?
So what came over from the House is the difference was, and help me remember this, but the cause of action was changed to an injunction, and there was language in there that we did relating to the, help me out here.
It was a relocation of the bill, but the only thing substantive that really happened was that injunction piece.
Okay.
The attorneys asked that things be repositioned so they didn't compete against each other, so we consolidated those. The language would say that the injunctive relief from a lawsuit up to that was the step down in liability. Okay. Otherwise, it's the same.
Did I butcher the pronunciation of your name? I apologize.
Yeah, that's fine, sir. It's Gwaltney. My name is Debbie Gwaltney.
I like that.
I would like to speak to you. I am a retired RN, and I would just like to reiterate how important it is, particularly at the beginning of a patient's arrival, to have someone there who can act and speak on their behalf, particularly a child or an elderly individual or someone who is, for whatever reason, unable to speak for themselves. Family members know what their family member looks like, acts like, speaks like on a regular basis. They can be there to give us accurate histories, whereas the patient may not be able to give an accurate history. They can even do things such as intercede in the event of a medication that might be prescribed, but for which the patient is highly allergic. It is an extremely valuable part of the healthcare team, and actually our healthcare system right now is based so that family members do play a very active role in patient care, patient protection, patient safety, and that doesn't even include all of the things that family members do when they are at the bedside, even in other situations. They take the place of care techs, they help with PT, they help with OT. They're just an integral part of the healthcare model that we have right now, and it's a part that is missing incredibly, and it's a comfort and to the patient, and it's the family member can provide information that no one else can provide.
Right, it's certainly invaluable to the care team and to the patient.
Yes, sir.
And
Yes, sir.
is always much appreciated. I personally had a patient die alone also, and it's been very tough. Thank you, Ms. Gwaltney. Gotcha.
Yes, sir.
Good deal.
Thank
All right,
you.
Mike Griffin and Lori Simonelli is in the batter circle on deck. And then Ms. Rich, Representative Rich.
Thank you, Mr. Chairman. I do have some handout that I'd like to give. If I could.
Lawson will be happy to get those, and we'll get those around. Thank you so much.
Thank you, Mr. Chairman. My name is Mike Griffin. I'm the Public Affairs Representative with the Georgia Baptist Mission Board, and appreciate the opportunity to address you very quickly. I'm handing out our statement from the Mission Board on this legislation. You can imagine if you did your sermons that way, how quick the service would go if you could just hand the messages out. But anyway, we are in support of this legislation. We commend Representative Ed Setzler for his great work in the House and the work that you all are doing here today. I pastored here in the state for 35 and a half years. Georgia Baptist Mission Board is the largest denomination in our state, representing up to 1.4 million Georgians, up to 3,600 churches. And during the pandemic, I heard a lot from Georgia Baptist saying, what can we do about this? Or can you contact the governor? I mean, it was a constant burden that was going on out there. And I really believe that this legislation strikes the proper balance that we all would respect regarding, as I would hear the governor say many times, our life and our livelihoods. And I believe this legislation falls within that vein. And I think it's something very important to have, and we really appreciate your favorable consideration of this. Thank you, Mr. Chairman.
Thank you, Mr. Griffin. Lori Simonelli, and then Dana Lloyd is in the on-deck circle.
I apologize for my granddaughter.
Oh, you're good. I love this. I love the sounds. You're good. That's great. Thank you for bringing her.
Can I take this off to talk?
Yes.
Hi, my name's Lori Simonelli.
If you wouldn't mind the podium and the mic
sorry.
there, you're good.
This is new.
You're
Well,
good.
it's the second or third time, I guess, now. My mother has been in a long-term care facility for 2 years. Accelerated dementia and a broken hip put her there. So this is her great-granddaughter. The reason that we need to be allowed back in is this is my mom. I don't know if I can hold the poster. These are the stages that's happened in this last year. They call it failure to thrive. Failure to thrive means that they just kind of lose hope and they don't eat and you need encouragement. My mom's 5'6", I'm 5'2", so she's quite a few taller than me. And she was 100 pounds. She didn't care anymore. And she didn't understand where I was. And when I see her, she says, I'm alive, you're alive. The dementia is accelerated because of this. And I'm retired from, was a patient care representative at Gwinnett Medical Center. I did 20 years in the ER. So I know what patient care PPE looks like. And they had a lot of agency there. December, my mother's unit or long-term care facility was COVID-free. November 7th, they got 1 case. It was full involvement in 4 days. There's a problem there. So if, like Representative Sussler talked about, if they can come and go about their lives and do their business and wear PPE, why can't I?
Thank you so much. We
Do you
appreciate
know?
that. Thank you, Ms. Simonelli. Dana Lloyd, and then Representative Rich. Here's Ms. Lloyd, probably.
Good afternoon. My name is Dana Lloyd. I'm a program director with the Georgia Advocacy Office. Georgia Advocacy Office is Georgia's protection and advocacy system for individuals with disabilities throughout the state of Georgia. And I want to highlight a couple concerns we have related to this bill. Our role is to work and stand beside people who experience disabilities and protect them from abuse and neglect. And it appears that HB 2290 was crafted with the best of intentions. I've heard a lot of the testimony today. The bill, however, comes with some unintended consequences that could result in significant abuses if passed as written. Specifically, the law provides that a patient's legal representative, as authorized through 3192, can in essence serve as the patient's determiner of medical procedures, guardian and conservator, without court oversight or protection associated with those laws. While it's certainly important for a patient to be able to designate someone to support them while during a medical crisis, allowing that designee to manage the patient's financial matters without restriction and manage medical decisions creates the potential for the designee to act in their own interest rather than the interest of the person. I'd also like to highlight that the essential caregiver portion of this bill we find to be helpful. We've supported people through the pandemic to lean on the ADA and the Office of Civil Rights support of the fact that people with disabilities can have access to caregivers during a hospitalization, and that is an option for people. So perhaps 290, while securing that in Georgia's code, this other opportunity for a legal representative definitely sets up some potential for abuse. We would like to believe that all people would act in the best interest and not take advantage of others, but based on our experience as providing protection and advocacy for folks with disabilities, we have found that not to be true.
We appreciate that. Ms. Lloyd?
Okay.
And we appreciate you coming, and,
Yes.
and thank you so much.
Thank you.
For what you do.
Okay. Thank you.
Representative Rich is in the room, and Mary Clausen and then Virginia Galloway are on the on-deck circle.
Chairman, I would be happy to let the other people speak before me,
Sure.
if necessary.
Yeah.
I would like the senator to be able to vote.
Yes. Yeah, out of abundance of time, from a time standpoint, is that what you're asking? Yes. Okay. Mary Clausen, Virginia Galloway, then Anna Adams. And we're going to, if y'all would please be respectful, because we do have members. I don't want to lose a quorum. I'd like to have a vote today. Thank you.
Of course. I'll make it very quick. My name is Mary Clausen. I'm speaking for another mother who could not be here today. She wanted to let you know that she has a daughter named Emily, who was 26 years old, who was riding a skateboard. The car hit her. She went flying. The car ran over her, ended up in a hospital. Even though her daughter put that she had permission to talk, to be an advocate and have HIPAA waived, the hospital was very negligent in not letting her speak to the doctors or the nurses about her daughter's care. This happened April 29th, 2020. After many surgeries and traumatic things, she ended up dying on May 6th with very, very minimal ability to talk to her daughter. Never talked to the trauma doctor, never talked to the orthopedic doctor. Many times when family members had said that they could not, they did go to see her one time a day before she died, and some of the hospitals didn't have PPE on. So it was just, she couldn't see her daughter, but yet there was not people following the guidelines. So she just says that she's being denied the ability to be the advocate for our families and can't even be sure the hospital staff is following the guidelines. So I'll let it go at that.
Thank you so much for representing her.
Thank you for listening. Appreciate it.
We appreciate that. Ms. Galloway, and then Anna Adams, and then Jill Case-Worth. Thank you, Ms. Galloway.
Thank you. Good afternoon. I will be very brief. I know you've got a lot to do today. I just wanted to say that Faith and Freedom Coalition supports this bill. It is very important to me personally. I just lost my mom about 6 weeks ago. Her last hospitalization, she was absolutely terrified to be in the hospital by herself, and she called us constantly because she said, they're not helping me, they're not coming. And I know they were busy, I get that, but this is why somebody needs to be in there with somebody who is sick with something that's non-communicable. And, and they've passed all the tests themselves. So I understand that there have to be guardrails for this, but I just really appreciate your favorable consideration of this bill for people like my mom and people with children that might be hospitalized and other people that I've heard of. So thank you very much for your time.
Thank you. We're sorry about your mom. Thank you so much. Ms. Adams, and then Jill Case-Worth.
Good afternoon, Mr. Chairman. I guess it may be evening now. I will keep this brief in the interest of time, but I am Anna Adams with the Georgia Hospital Association.
And on behalf of our more than 160 hospitals, I come to you today to respectfully ask that you oppose House Bill 290 as written. I'd like to start by saying that Georgia hospitals, first and foremost, absolutely support visitation of family members to patients. And for the purposes of this discussion, and somewhat in response to Chairman Setzler, hospitals put the people in their facilities into 3 buckets. There are patients, there are staff, and there are visitors, regardless of the reason that the visitor is in the facility. Whether they're making a decision, whether they're visiting, whether they're bringing flowers, they are a visitor. So, all of the family stories that we have heard have been heartbreaking, and I hate that at the start of COVID, we had to make some of the decisions that we made, but we've come such a long way. And many of our hospitals are now open to visitors, very much in the same way that they were prior to COVID. We would like to be able to support House Bill 290, but not at the expense of our patient safety and our staff safety. So I will quickly highlight that our 5 main concerns with this bill are the legal representative piece, the limited flexibility that reasonable safety standards would allow, the cause of action in the bill, which I understand has been removed, the removal of the governor's executive authority, and the fact that as of March 10th, this bill is no longer compliant with CMS guidelines. We have submitted to each of you a copy of proposed substitute language that we think is better for patients and better for visitors. It accomplishes the same goal without putting anybody at risk. So you all should have a copy of that. I've emailed it and I've put it on your desks as well. But it does first and foremost preserve the patient's decision-making ability. And you'll hear from some of our hospital members in just a few moments who will touch on each of these topics so as to not be redundant. But I do appreciate your consideration today, and if you have the opportunity, would ask that you support alternative language that is safer for hospitals and safer for our nurses and doctors who have been on the front lines of COVID for more than a year now.
Thank you, Ms. Adams.
Thank you, sir.
Appreciate your coordination. Ms.
Yes, sir.
Case Worth, and then Dr. Robert Jansen, and then Deb Bailey.
Good afternoon. Thank you for welcoming me here, Chairman Watson. I'm Jill Caseworth. I'm the Chief Nurse Executive of Wellstar Health System. I've been a nurse for over 40 years. I've worked at the bedside, and quite honestly, in the last year, I've supported a team of 25,000 heroes as they have stood in this disease process and been committed to caring for these patients. Wellstar and the hospital industry support visitation rights and agree that uniting patients and their loved ones is an integral part of the healing and recovery process. However, we've got to recognize that this pandemic created an unprecedented hazardous environment in our facilities, and it required us to make incredibly difficult decisions to restrict visitors and family in order to reduce the transmission in our facilities and, quite honestly, the spread within our communities. We worked really hard with health systems across Georgia, the country, and our public health officials to integrate the changing recommendations that were coming and to update our visitation policies to be congruent with the current situation in our regions and across the state of Georgia overall. Our job, one, was to protect our team members initially, because your community members, our family members, were depending that they would be there to care for these patients day in and day out. Secondly, we were looking at those most vulnerable patients that were within our community, in our facilities, and trying to prevent the spread there as well. If we think back to the beginning part of the COVID, I know it's been a year, we did have shortages of PPE, and there was significant concern about what we did not know and what was yet to come. I can tell you that, for an example, we were fortunate to have a pretty solid supply chain, but in July, in our second peak, when in Wellstar we had over 450 patients in-house, we were using 500,000 gloves a day. So preserving that supply chain for those that were at the front line, taking care of the patients, was essential in order for us to continue to provide the care that we had. Had we had usual and customary visitation and or opportunities at that point in time, I can tell you I couldn't stand here today and suggest that we would have had adequate PPE for our staff overall.
Caseworth, I sure appreciate that. Thank you so much. And Robert Jansen, and then Deb Bailey is in the batter circle, and in the hole is Julie Wyndham.
Good afternoon. Thank you for letting me be here. I am Robert Jansen, the Chief Medical Officer at Grady. And I first want to say I understand this bill. I mean, the tragedy that we have witnessed and the difficulty that families and patients have faced has been unremarkable. It's just awful. I just have a couple of concerns that I want to talk about. One is the concern of victims of abuse and how do we protect those. Frequently, victims of abuse, sexual abuse, sex trafficking, elderly abuse, child abuse, they have a difficult time saying no to who represents them. So we need to protect them. We need to have some provision that allows us to say no to a visitor there. Psychiatric patients is another area. 1013 patients, people who are prone to violence. We need to make sure that we don't allow people to come in that may provoke additional violent acts. So we need to have provisions to protect those patients and protect the staff. The victims of violence in a similar situation, and if you have a victim of violence, sometimes you don't know who perpetrated that, and they may not know either. So allowing them unfettered access with visitors, I think, is an issue that we need to address. We have at Grady a burn unit, severely burned patients. Many of those really cannot have people physically present in the room. It's dangerous. The risk of infection to them is incredible, and we have to protect them. So we have to have a provision to not allow in-person visitation for those types of patients. And that would also apply actually to some of the immunocompromised patients who have diseases that would not allow in-person visitation at any time.
We appreciate that. Absolutely. And that makes perfect good sense. Thank you, Dr. Jansen.
Okay.
Deb Bailey, Northeast Georgia Health System. I'm sorry. You have a quick question?
Yeah.
Certainly. Number 6.
Yes, sir. Doctor, is there a way to fix that in this current form, in this bill?
Well, I wish I could say I know how to do that, but there are a few things, that we would like to see. The other thing that I have concerned about is internal disasters where we can't have visitors in the hospital, and we have that at Grady, and mass casualty events. So those are other things that we need to look at to make sure we don't have access to the hospital when we need to shut it down for other reasons.
Thank you, Dr. Jansen. Do you have another question? Dr. Jansen, I apologize. We got a... Ms. Bailey, can you send Dr. Jansen back in?
I'm sorry.
Yes, I will.
I'm sorry, you
trying to
have another
follow your
question
rule.
there. Yes.
Thank you, Mr. Chairman. Some of the points that you brought up were things that I've been thinking about. I like this bill because of family connection that I have. And, one of the things that you said about the burn units and things like that, on line 84 it says that hospitals shall not be prevented from imposing reasonable safety requirements specific to each residential setting to effectuate the in-person physical contact. That reasonable standard and the shall, do you think that helps at all in the setting of a burn unit?
It may provide some protection, but the mere putting on any type of gown, gloves, et cetera, going into a room, if you've been in those rooms, you know how close you are to the patient, and inevitably someone is going to want to reach out and touch the patient. That's human nature. We crave touching. And that's where it becomes dangerous. You can't control that. We can't police those types of activities.
Thank you.
Mm-hmm. Okay. Thank you.
Yes, thank you.
Could I address Dr. Jansen's
Chairman,
issue
yes.
directly?
Yes.
Mic number 9. To Dr. Jansen's question, I appreciate the question. That's the burn victim is exactly why we wrote lines 77 through 83. Is exactly why we wrote it. We wrote it for that specific circumstance. It talks about operating rooms, transplant wards, and in this case, a patient requiring physical isolation for exceptional immunocompromised conditions.
Got you.
And
Yeah, that answers your question.
for patients
does.
requiring physical isolation, so physical isolation in those circumstances.
Exactly. I think I'm about to call you Dr. Hatchett, your dad.
That's my dad.
He probably would have shaken his head yes there too. Thank you. Ms. Bailey.
Mr. Chairman and members of the committee, my name is Deb Bailey and I represent the Northeast Georgia Health System in Gainesville. I'm a master's prepared nurse, and I'm speaking specifically to our system over the last year. We live in Hall County. We have 4 hospitals, but the main hospital is in Hall County. At one time during this period, we had a 35% positivity rate in Hall County for COVID. That was one of the highest in the entire United States. And that resulted in 350 positive patients in our system in a 750-bed hospital. We had 60 patients waiting in our EDs. We had patients in our psychiatric facility, in the gym on cots, and we took very seriously our responsibility, and never in our history had we ever limited visitors as we had to do. But our staff, we ended up with 1,000 of our staff being positive for COVID, and we lost several of them. We're asking today that you allow our infectious disease physicians and those that are responsible for the care of our patients and our staff the ability to make that decision when that is necessary on when patients are allowed to visit.
Thank you, Ms. Wyndham. We appreciate that. Tim Kibler, and then we have Mary Lee. Ms. Quinn is on Zoom. So, I'm sorry, I jumped. I went from...
I am not Tim
I'm sorry,
Kibler, Mr. Chairman.
You're not Tim Kibler. That sort of threw me off there. Sorry about that. Ms. Wyndham.
That's okay. Thank you, Mr. Chairman. Members of the committee, my name is Julie Wyndham. I am the Vice President of Government Relations for Atrium Health Navicent. We are a health system in Central Georgia, headquartered in Macon. And you have a letter in your packet from a physician at our hospital, Dr. Tom Oliver, expressing the clinical and safety issues we have with this legislation. Also, you have heard from a number of my colleagues. I'll echo what they say about that. But I would like to spend my time talking about some of the legal issues we have with this legislation, particularly the legal representative language. State and federal law is very clear that a patient's wishes with regards to their health care should always be paramount. And in fact, in every provision of the advanced directive law in this state that this General Assembly has passed, they make that clear that that is the will of the General Assembly. However, we feel that this bill impedes that ability of that patient to make their own decision by imposing a legal representative on a patient who may not have affirmatively chosen to have a legal representative. And the sponsor is correct that if you do already have a power of attorney, durable power of attorney, or a living will, that person would be your legal representative under this language. We certainly appreciate that reference. But let's talk about the fact that only 1 in 3 people in the state of Georgia who are patients actually have an advanced directive in place. So for 2/3 of the patients that are coming to our hospitals, you're telling them they have to have somebody helping them make their health care decisions, even if they choose not to. I would submit to you that a patient's right to make their own health care decisions should always be paramount if they have the capacity to make those decisions, and that you need to think long and hard before you take that away, especially in a piece of legislation that doesn't include all the protections that the advanced directive provisions of our law include, such as how that advanced directive is created, revocation, liability protection for both the provider and the decision maker. This bill does not provide any of those protections. So we would encourage you to keep the patient's right to make their own decisions paramount.
Thank you, Ms. Wyndham. You have a question? Yes.
Julie, thanks for being here. So what about the language of the bill instructs you that someone who is competent would lose the right to make decisions about their own health care?
Well, Mr. Chairman, I have not seen the sub, so I can't appoint you to those languages, but in the original bill, as it came out of the House, lines 31 through 38, I believe it's around line 33 or 34, says unless a patient designates somebody as a legal representative, they shall have one. And then they go to the 3192. So you are required.
35 and 36.
Yep.
Right, unless otherwise stated by the patient or resident, such legal representative shall be the person
And-
authorized or empowered to act on behalf of the patient or resident pursuant to Code 1392, which Chairman
That may not be
Setzler-
the way the sponsor intended it, but that's the way we read that language, so.
Okay.
Okay.
Thank you, Mr. Chairman.
Chairman Setzler.
Callously dismissive, that's the definition of a legal representative. And there's nothing in the definition of legal representative that gives rise to this power. I mean, the operative part of this bill is down below that talks about no policy shall be established that limits access, but the definition of legal, that's the definition section. That's not the operative section of this bill. It simply defines it simply defines that the legal representative shall be the person that's established in 31.9-2. That establishes that nothing in this bill changes existing state law.
Thank you. All right, Tim Kibler. And then we have Ms. Quinn on Zoom.
Did you already do the on line 78?
I hadn't done it. Kibler, floor is yours.
Ma'am, Mr. Chairman.
Yes, sir.
Thank you. My name is Tim Kibler. I'm with the Georgia Alliance of Community Hospitals. We are a 85-member hospital group that is made up of Georgia's not-for-profit hospitals. Our members provide the majority of care across the state of Georgia and have seen the majority of patients with COVID during this past pandemic. You've heard from some of our membership with the challenges that they have faced as a result of this pandemic. And it has indeed created similar challenges for families across Georgia, and we recognize that, as you've heard from my colleagues. There's no debating the therapeutic benefit of family involvement. However, and I do want to, I guess I should say, however, we still have grave concerns about this bill. Appreciate the movement that has happened on the part of the sponsor, but we are still in a status that, I guess as my friend Mike Griffin just said a moment ago, your responsibility is to balance the needs of all. If this bill, if Chairman Setzler's bill was the law on January 1st, 2020, we would have a higher number of families who had suffered significant tragedies as a result of more contagion coming on campus. We have to be very concerned about the future contagion that we will have to deal with. And this allows for that contagion, demands the opportunity for it to be brought on campus. So we still have grave, grave concerns. Would ask the committee to try to maximize the protections that are provided to Georgia's patients and to our staff. And I'll be glad to answer any questions.
Thank you, Mr. Kibler. Any questions? Don't see any. Thank you so much. We have one person who is Zooming with us, and I think she is teed up there. Ms. Quinn, the floor is yours.
Thank you, Chairman Watson and members of the committee, for this opportunity to speak to you on behalf of the Alzheimer's Association Georgia chapter. I'm Mary Lee Boatwright Quinn. COVID-19 has shed light on the vulnerability of people living with dementia. Those with dementia diagnosis are 2 times more likely to contract COVID and 4 times more likely to die from it. In addition, the CDC indicates that in Georgia, there were over 1,700 more deaths from dementia than expected in 2020. We are certainly grateful to Representative Setzler for bringing attention to this issue. The association has always been a proponent of hospitals allowing patients with dementia to have a care partner with them throughout the healthcare delivery to ensure the patient's physical and emotional well-being. That care partner or legal representative is critical to relaying accurate information to healthcare workers as they are assessing and delivering care. Of course, we agree that hospitalists are the experts in how to do so safely and given whatever public emergency we might find ourselves in the midst of. We support the effort of this legislation to address social isolation on families in long-term care, and we must make sure that we don't make the same mistakes again, that we have to prioritize long-term care settings. Other states have passed or are considering legislation to establish emergency operations centers focused on long-term care and are requiring long-term care settings to have social isolation prevention plans in place. And I hope that this legislation is not a one and done, but that we decide to continue this conversation so that we can learn from the mistakes that we've made and make changes to how we respond next time around.
Thank you so much.
Thank you for the opportunity to speak.
Really appreciate your thoughts on this, and certainly appreciate your thoughts, especially relating to Alzheimer's and dementia. Thank you so much. And so that's it, wrapping up from a testimony standpoint. I would like to, if we, Chairman Setzler, if you'd like a couple minutes, and then, or we can go ahead with amendments, and then you can follow up whatever you want. I'll let that be your pleasure.
I don't want to talk past the close. I know there's members here whose personal lives are literally ripping them out of the room as we speak. So
Yeah, no, I understand. Okay. Yes, sir. I respect that. Thank you so much. I have an amendment. If I want everybody to listen closely, because it's a little complicated. If we're looking at lines 86, striking the word physical, and then after the semicolon on line 87, the word including, then a comma, but not limited to requirements, and striking provided however. So line 85, halfway through that, residential setting to effectuate the in-person contact of legal representatives with patients or residents required pursuant to this code section, including, comma, but not limited to requirements that a hospital or long-term care facility may temporarily suspend or terminate. That would be the reading of that. That's how that would read. Then on line 101, and again, as we discussed, the cause of action is an issue. This does allow for the injunction, so I wanted to make sure that we're clear on that the court is only for injunctive relief, and that would mean striking the language on lines 104 through 111. And then continuing on with the aspect relating to long-term care facilities on line 120, again striking the word physical on line 120, and then on 122, the same thing to this code section, semicolon, including, comma, but not limited to requirements, and I struck the words provided, however, that a long-term care facility may temporarily suspend or terminate the access of an essential caregiver. And then again on line 139, after the word for, putting only in there and doing the same thing as I did before on lines 142 through 149, striking those lines. That is my amendment, and my thought process was trying to protect victims of rape or attempted murder and trying to limit the liability to an injunctive relief only, and that was my thoughts. I'll look for a second for the amendment. Second from Senator Kennedy. Any discussion? We'll have a discussion from Senator, I'm sorry, about to give you a demotion there, Chairman Setzler.
Mr. Chairman, I've been called worse in this very room before. I'm just trying to understand the language. I get the tort piece. I'm trying to understand up above on line 85. I was trying to sort through my page. What is it saying? Just briefly, just for clarity, Mr. Chairman, so I can understand it.
We're on line 86. We're taking out the effect of the in-person, the physical contact. In other words, contact without being physically present. and we wanted to make sure that the provided, however, did not limit any of the requirements that the hospital long-term care facility may suspend or terminate. That was the thought process.
So in the substance is, Mr. Chairman, you're taking away the ability to be physically present in a facility in some setting?
Yes, in some setting. That's correct.
Okay. I mean, it's the chair's committee. I mean, the core of this bill is to provide a physical access under whatever means.
It does say in-person contact, but there will certainly be times when it can't be physically present, and that's why I wanted to be clear on that. Okay.
73, 75, 81.
It does, you're right. So I should take those out also. 73 also says physical contact, and I think I heard 81 says physical contact,
75.
and 75. I apologize about that. 81, I think we did list that. Yeah. Uh-huh. Okay. Is there any others, Ms. Howington?
Not that I'm saying.
Okay, we have an amendment, we have a second, and we've had discussion. All those in favor of the amendment, please raise your hand. That's 9. All those opposed? 1. All right. I'll entertain. Did you have a?
I just had another potential amendment.
Okay.
You still entertain that?
Yes.
On line 78. No, that's not it. On line 78, I was hoping to, after the word basis, add including but not limited to, and then delete the word for.
Okay.
That would give more flexibility. And then on line 81, I'd like to delete for up to 48 hours. Line what? Line 81, 82. Delete for up to 48 hours.
And the logic on the deleting of for up to 48 hours, what was the logic on that?
There can be situations where 48 hours is, I'm not quite sure why that particular number was chosen.
Okay.
It might need to be shorter, it might need to be longer, and I think the hospitals need more flexibility on that.
Okay. Do I have a second to that?
I think that that's right, for up to 48 hours.
Yes, and that was on line 81, and then the other was line 78. Can you do this line 78 again, please?
Yeah, so after the word basis, it would say, it would add including but not limited to, comma, and then delete the word for. So it'd say, case-by-case basis, including but not limited to patients in operating rooms, et cetera, et cetera.
Okay. Mr. Beal, do you have?
And that might account for some of the other situations that people have raised.
Okay. And could I include your, in your amendment there on line 63, the word physical? We're deleting that too. I apologize. We found
Sure.
another physical.
Have at it.
All right. So we had an amendment. I think, did we have a second on that? Senator Orrick, thank you for your second. And any discussion?
Mr. Chair, I would simply say the 48 hours was there, so it's a defined time. An unlimited amount of time, I believe, guts the bill because it allows it to be an unlimited delay by a clinician.
It just doesn't define it, but I understand your opinion. Any other thoughts, questions? So we got amendment, got it seconded. We're clear on that. We've had discussion. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. Opposed? Got one again? All right. All right, so we have the bill LC 338808 ERS, and we have a substitute, we have another amendment. Okay, all right, have another amendment. Let me recognize Chairman Burke on 14.
Thank you, Mr. Chairman. First, I want to thank the author for his concern for patients in Georgia, concern I think all of us on this committee share. I'm a little bit concerned about the ability to us to perfect this bill at this late time in this session. As the chairman said, this is new law in Georgia. Our healthcare system has just gone through a shock like it's never been through in my 63 years, and I would say it's probably much longer than that. And I'm just extremely concerned that this bill needs more work. And so what my amendment, and I hope they passed out a copy to everyone, basically removes all the language up until you get to line 151. And so it basically allows the hospitals to have a visitor policy that is public. It restricts hospitals from imposing any standards that are not already part of the CMS guidelines, and it would allow regulatory action from the department if hospitals restrict visitors beyond what should be done. And I think that would let the public know we want to work on this issue, and then give us time to continue to work and try not to pass language that I think, in spite of the best intentions and work on this committee today, is not anywhere near where it should be for residents of Georgia. So.
Thank you, Chairman Burke. I just want to make sure that everybody has a copy of this. Do I have a second on the amendment? Senator Orrick seconds. Discussion. Do you have a...
Mr. Chairman, this is obviously a substantive amendment. It's in the breast of the committee. I'll leave it to the committee. I think the committee members can anticipate it's not in keeping with the bill, but I trust the committee's wisdom.
Okay. Any further discussion? All right. Senator Orrick.
Thank you. I appreciate Dr. Burke's amendment and agree with the thrust of your remarks. And when we hear such a significant, resounding messages from our medical community and our health community, the standard bearers who have been on the front lines, I find it impossible to walk away from that body of evidence and advocacy on their part and pass anything other than what Dr. Burke has presented.
All right. Thank you, Senator Orrick.
Thank you.
Any further discussion? We've had the amendment. I'm sorry, Senator Dolezal on number 7.
Thank you, Mr. Chairman. I'll add quickly, I think this is a sensitive issue. This is personal for me. I stood outside North Fulton Hospital almost a year ago today with somebody who we all know, while his son was upstairs with a gunshot wound in his head, self-inflicted gunshot wound. He was not allowed in the hospital for days. His wife was not allowed in the hospital for days. This bill may not be perfect, but I think that if we go back to the status quo of what we have lived through in the past year, that is also far from perfect. So I think as we weigh the balance here, I think that we heard this went through 4.5 hours of testimony in the committee and the House side. We've been here for 2.5 hours. I think we've given this reasonable consideration. I would hate to see this bill gutted, because if I've heard from anything from my constituents, other than all the noise we've heard around the elections, I would have to say this particular issue has been the one that I've heard the most from my constituents. I would encourage us to think strongly before we do gut this bill. Thank you, Mr. Chairman.
Thank you, Senator Dolezal. Any other discussion? If not, let's let the will of the committee. All those in favor of the amendment that's before you, please raise your hand. All those in favor. This would be an amendment to the bill.
The amendment number is 33-1968.
Everybody has that in front of them. I want to make sure everybody has it and questions are answered before we take a vote on this. Ms. Leader, do you have it there? Do you have it? No questions? Okay. All right, let's take a vote. All those in favor of this amendment, raise your hand. 1, 2, 3, 4, 5, 6, 7. That's 7, correct? All those against this amendment? 1, 2, 3. The amendment passes. All right, so that's where we are. So any other amendment, any other discussion? We have a motion for due pass on House Bill 290. It's now a substitute, but it was amended as a substitute. So we have anybody have a due pass on that? Move due pass. Second. Okay, all those in favor of the House Bill 290 as substituted, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. That's 9. All those against? 9-1. Okay. All righty. Thank you. Thank you, Chairman Setzler. This moves forward to rules.
Thank you, Mr. Chairman.
All right, so we're at House Bill 128. Representative Williams, Waycross, Georgia. Thank you.
Thank you,
This
sir.
late
I
hour.
appreciate the opportunity to be here.
Yes, sir.
Mr. Chairman, Senators, thank you for the opportunity. Bring before you just a little simple bill, House Bill 128. This is spurred from constituents to make sure that there's no discrimination from providers or insurers against someone with a developmental disability, whether it's physical disability or mental disability. And this just goes right into effect with the federal ADA law that was passed back in 1990. And a lot of other states have adopted this. This bill passed unanimous in the House last session. The problem with COVID interrupted before we could get it crossed over. It's passed unanimous again in the House this session. I'll be glad to answer any questions, and we even have Gracie here along with her parents and other people that are willing to come in and testify if you so wish. Thank you.
Thank you. We certainly appreciate that, Representative Williams.
I know it's a long day, and I don't want to.
I'll leave it up to you, Representative Williams. I know, goodness gracious, we have a lot of wonderful people here that have signed up. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
A lot of them realize it's
15 have signed up.
It's in the sake of time. We have Gracie, her mom and dad here.
We'd love to hear from her. I'll leave it up to you. I was anticipating what you were about to say, but I don't want to.
I'll leave it up to the Senate.
If we could have
okay.
Who this bill is named after, we certainly would appreciate that.
Thank you so much.
All right. We're ready for a motion, but we want to hear from y'all. Thank you so much for being here and for doing this. Are y'all from Ware County?
We are from Worthing, Georgia, which is just outside of Sandersville,
Yeah,
right in the middle of
certainly.
Georgia area.
Highway 15. I've traveled that a few times.
Yes, sir.
The smallest jail in the.
That is correct.
Yeah.
Aaron Burr was there.
That's right. Okay. We're getting off subject here. Okay.
Committee members, the honor is ours. Thank you for allowing us to be here. My name is David Nobles. This is my wife, Erin. And of course, this is Gracie. our oldest son, Walker, is out in the hallway. And we are here today to urge you to vote yes for Gracie's Law, House Bill 128. Our story is this. Gracie was born with a congenital heart defect, like so many babies with Down syndrome. Her heart defect was an atrioventricular canal defect, which is commonly corrected via open heart surgery around the age of 4 to 6 months. While waiting for the narrow window of time to have her heart repaired, Gracie rapidly deteriorated, and we spent months at the Children's Hospital in Augusta. Due to her heart defect, she developed complications of congestive heart failure, numerous times had a collapsed lung, had to be placed on a ventilator for pneumonia, went into renal insufficiency, and had to have a feeding tube inserted. We almost lost her several times, and Aaron and I were living a nightmare. By God's grace, her surgery day finally came, and miraculously, both her heart and kidneys were healed or repaired and are now better than ever. She's a cheerful, happy child with a bright future. She knows several words and has reached many of her milestones, goes to nursery school, and is already learning to count. She will have a great life ahead of her. She loves generously and is adored by many people. Her life is worthy, and we could never imagine our lives without her now. During our long ordeal, we learned that if things have gone differently and Gracie had needed an organ, we could possibly have been not put on a transplant list due to her disability, her different ability. We knew that Georgia needed a law to protect some of our most precious assets. And that is when we reached out to Wayne Pearl, who is the author of Evie's Law. That's a law that passed in Louisiana in 2019. He gave us a copy of the bill that passed in Louisiana, and we in turn sought out Rick Williams and Mac Jackson to carry this important piece of legislation. With this bill, no one with a disability or their family will ever have to worry about not being placed on a transplant list based solely on their disability. As long as the individual has aftercare and are capable of following the prescribed regimen, they are entitled. If discrimination occurs based solely on the disability, it provides a local, practical remedy to fight discrimination in a timely manner. Make no mistake, this bill will save lives and improve lives for people with disabilities and their families throughout Georgia. Bills like Gracie's Law are sweeping the nation and have passed in several other states. Georgia needs to be a safe haven for people with disabilities, and those people need to know they have the same right to life as you and I. This bill is not just for people with Down syndrome, it covers all disabilities. No one should have to worry about whether or not they are valuable enough to receive adequate medical attention. Everyone is valuable, everyone is unique, and everyone is worthy. Thank you.
Thank you so much
thank
for
you.
being here and for having Gracie here with us.
Thank you.
The
pleasure's all ours. Thank you.
So of those 20 people that signed up, sounds like they're all the favorite. So that's good. Representative Williams, what would be your pleasure?
Entertain a motion to pass.
All right. Well, looks like we have recognize Senator Burke.
Thank you, Mr. Chairman. And this bill brings me back when HIV was a death sentence, and so many changes have occurred with medical ethics during this time. And going back to what I said on the bill we just heard previously, I mean, these are tough issues we're dealing with, and I think that the time is right for us to move forward with this type of legislation. And I'd be honored to make the motion to pass House Bill 128 and thank the representative for being here.
Yeah, LC 460360. We have a do pass. We have a second by our caucus leader, Kennedy, and further discussion. I see none. All those in favor, let's do affirmation here. All those in favor say aye. Aye. All those opposed, like sign. Passes unanimously. Thank you so much.
Thank you so much.
Thank you all very much.
Thank you.
It's the right thing to do. Crips Camp. I just saw that movie this week, and it lifts up the battle for people with disabilities to be truly and fully at the table on an equal footing with the rest of society. And it's I couldn't help but mention that in the wake of the passage of this bill.
Thank you, Senator Arnott.
So much.
Thank you all very much.
Yes.
Thank you.
Dr. Al.
One more very short comment. I'm glad we passed this bill. This is a good bill.
Thank you so
all.
much.
I want to encourage everyone in this room and everyone who's outside also to check that the organ donation checkbox on your driver's license is checked, because we need to address that there is a huge shortage of transplant organs in this country, so we can hit this from both sides. So thank you.
Thank you so much. Appreciate that thought.
Amen.
Thank you, Representative Williams. Tell you what, sort of wish we could end with that one. Should have put them last. That was. I tell you what, I don't think we can top that one. Oh my goodness, but we're going to try. House Bill 117, Representative Mike Walensky is going to be represented by Senator Randy Robertson. Hopefully he'll be coming through the door. House Bill 117, it is in your folders. At least I thought he was. Maybe not. Yeah, if y'all don't mind checking, and if not, we can. No, I'm not going to meet tomorrow morning. we're going to have a quorum. 117 is there. You're happy to present it? Okay. We'll let Senator Kirkpatrick present it from her chair.
Yeah, we've seen this bill before, y'all, and it deals with the big problem of dextromethorphan being sold to minors who are using it for not good purposes. And I don't know all the terms that Senator Robertson used. I think there's lean and some other things that they use as to concoct. And so the bill basically requires that it can't be sold to a minor, and I think it also puts it behind the counter.
No, I don't think it puts behind the counter, but it does make it unlawful for a minor to purchase it. I'll be happy to.
And I think someone who buys it.
This is the same bill that we passed out before.
If there's home delivery, someone has to sign for it that it's an adult.
Okay. I'll be happy to accept a motion. Motion do pass. Chairman Burke. Okay. House Bill 117. Do I have a second?
Second.
Second from Senator Kirkpatrick. All those in favor say aye. 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 All those opposed, like sign. Passed unanimously. Thank you. All right, then we are on to House Bill 645. We have I believe we have a substitute. This one has been heard. There have been some changes. If Senator Brass would come in the door, hopefully they can hear us out there, and we can discuss this bill. All right, the floor is yours.
Thank you, Mr. Chairman. All right, so HB 645, which I believe y'all heard last week, come back, made a couple little changes specifically in the dispensing area, but I did want to kind of go through the bill briefly as quickly as I can just to make sure everybody's clear on everything outside of the dispensing piece. So if you'll look, I'm reading off of LC 338806S, and so in Section 1 and throughout the bill, you're going to see we're adding "and products" after THC oil. What that does is we defined in HB 324, we defined what products is and what they are, and you'll see that on lines 53 through 56. So we're simply adding, and it's really more cleanup language than anything to anywhere that we're going to allow THC oil, we're allowing these products as well. So Section 2 is that continued. And then if you get over onto page 5, what we've done here, the commission has kind of made a few requests. We require them to submit an annual report. So what we've done here is kind of answer their call. I'll kind of point out a few here. If you look on that subsection 13, basically saying that reviewing new treatments and delivery methods for low THC oil, they're just going to continuously be monitoring those. And if you'll remember what we did, any new illness that's going to be added, it still that has to come from the Composite Medical Board in conjunction with DPH. So the commission doesn't have the ability to do that. Of course, nobody has the ability to do that except for us, the legislature. But they are going to be reviewing that and continuously monitoring that. Subsection 14, to be responsible for the non-criminal enforcement of the provisions. Simply, this was really requested by GBI. GBI only wants to handle criminal investigations. They don't want to be responsible for the inspections of any facilities. So this is simply giving the commission the ability to handle the inspections. If you look at 16, it's to enforce qualifications for the licensor. 17, to levy fines. In HB 324 that set up the program, basically we only gave the commission the ability to take away a license. So we're, instead of a 1 strike you're out, we're basically giving them a 3 strike you're out with some fines. But the ability to revoke that license is still there. And I'll kind of come back to that in a later section. Section 3, if you'll remember, we set up 2 licenses, 2 production licenses for the university system for our land-grant universities. That is for University of Georgia and Fort Valley State are our only 2 land-grant universities in the state. But the way we had it worded, we said that the commission they shall issue licenses to those 2 universities. So far, neither one of those universities has had any interest in obtaining that license. So all we're saying here is upon the request from one of those universities, then the commission shall issue that license. So it's basically just making it to where we don't have 2 licenses that we've mandated that are out floating around that nobody's actually requested. If you'll get into section 5 on page 8, we're doing something very similar. If you'll remember, on the dispensing side of things, we allowed the pharmacies to kind of have the first crack at it. And part of that was we just couldn't really come to an agreement on how we were going to dispense these, and we kind of just really ran out of time. And the governor came in and said, I want the pharmacies to have first crack at this. So that's what we did. But so far, we haven't had any pharmacies come forward. And so, again, what we're doing is saying, rather than making the State Board of Pharmacy develop an annual non-transferable specialty dispensing license, we're saying that once a pharmacy comes forward, then they must issue that license. So, and then subsection 2 there, this is the dispensing. And because this is probably going to be the most debated part, if it's okay with you, Mr. Chairman, I'd like to come back to that. That's on page 8, right up under where I was talking about the pharmacies. It starts on line, I believe that's 479. My first number's cut off, but it's page 8. I am going to come back to that, though, so mark that. Section 6. So what we did back in HB 324 2 years ago, we set up a Medical Cannabis Commission Oversight Committee, and really that was to give the legislative branch, give us a little bit more oversight of the whole process. Well, number one, those appointments were never made. And we're not doing anything with the appointments. It's still up to the Speaker and to the Lieutenant Governor when they want to make those. But what we are doing is we're actually beefing up their legislative oversight a little bit. And you can kind of read through there and see things they're doing, such as they shall recommend to the Commission a process and a plan for an accredited lab testing of the products. That was one thing we didn't. The lab testing is one thing we never addressed in 324. I don't feel like the industry should be testing their own products. You need some sort of third party coming in and doing that. And so at some point we're going to have to get that addressed, and quite honestly pretty quickly. If you go on to the next page, page 11, I believe that's line 251, D. I know this was in HB 645's original version. The Oversight Committee may regularly seek input from patients and physicians. I know Senator Kirkpatrick, I think you had made a recommendation for that to be a shall. That did not make it into this sub, but I'm certainly did.
Yeah, just, Mr. Chair,
Mr. Chairman, I think she had a.
To that briefly. Yeah, I did make an amendment that changed that word, but it also added some more physician oversight to the process, and
Okay.
I'll make that amendment again when you've quit talking.
Perfect. All right, so Section 7, Section 8. So if you'll go to page 14, I believe we're still in Section 8. What we saw in the application process for these licenses, some of these companies hadn't quite gotten their banking set up, and there were some there's just different bonding or surety bonds that are available on the market, whether it's some sort of cash holding or collateral. The whole point of the bond was to prove that they are financially capable of putting product onto the market. And so simply all we're doing there is just saying, that type of bond's not the only one you can do. We're adding a couple other options. That's on page 14. Now if we'll fast forward, 16 and 17 is basically everything we did in Class 1 licenses we're doing in Class 2 licenses. So now we're getting into Section 10. Again, we're just adding and products. That's just cleanup language. I'm still in Section 10. I'm sorry, I'm getting into Section 11 on page 21. So here what we're doing on line 509 is we put in the 1,000-foot radius. Basically, you can't get within churches, schools, whatnot. What we're doing here is if by locally by zoning, they can kind of change that if they need to, because once you get into, number one, in rural Georgia, we saw some issues with the production license applicants. You get in rural Georgia, you got a church on every corner, and then you get up here, say, in a more urban area in the city of Atlanta, and you got churches and schools and all that. Again, we don't want these near those, but if the local government feels like it's still safe, we're giving them the ability to make that change. Again, that's just a local control. Section 12, still on the same page, GBI. Again, this goes back to what I said earlier. GBI wanted to solely be in charge of investigating any criminal behavior. They did not want to be in charge of inspecting these facilities. So that's what that language does. And it simply says they are going to be investigating criminal activities only and not in charge of the inspections. And the way it was originally worded, that was the way it was or is currently. Section 14, getting down on line that subsection A, starting on line 574, or really the new language starts on 576. Basically, what this does is if a retail or a cultivation license is revoked, this simply gives the commission the ability, under the same process, gives them the ability to issue a replacement license. And again, this was one of the requests that came from the annual report from the commission. Section 15, if you go to page 25 on line 609. So the way the law is right now, if any physician has ever referred a patient onto the registry, then at no time in their career can they ever be involved with a license holder, have any sort of business relationship. So what we're hearing what we've heard from some retired doctors, we've heard from other doctors that are looking to kind of change profession, or not change, but transition their careers, I'll say. As long as there's no current relationship with these patients, then they would be allowed to get into the business. If we'll go to page 27, looking down at starting on line 679, all we're doing here is basically saying if you're an employee, a contractor, or agent of a licensee, one of the 6 applicants that are going after this license, if you work for them, as long as you have proper identification, it's basically giving you immunity from any drug charges. And we did add the word transport in there. So it's with the production, manufacture, distribution, or transport. So in the necessity there of adding that word is if we're going to allow dispensing, which again I'm going to get to that in a minute, but if we're going to allow dispensing, you're going to have to take product from the production facility to the dispensary. And so that person, as long as they have their ID badge with them, they will be able to do that. Getting into section 23, and I'm on page 29. Simply all we're doing here is we're allowing any university or any college in this state, if they are doing any kind of medical research, we're allowing them through a partnership with one of the 6 license holders, we're allowing them to obtain an amount of the oil or the product so they can continue their research. And one of probably the best example of this, Clark University has a very robust prostate cancer research program going on, and they would like to be able to obtain some of the oil or this product to continue their research. So it's still very stringent on their ability to obtain that oil. They have to partner with one of the 6, and it's for research purposes only. We're not giving them a new license. We're not allowing them to produce anything or manufacture anything, simply do research. So that's section 23. That pretty much wraps up everything outside of dispensing. So if you'll go back to page 8, and we're on lines I believe that's 179. Again, my numbers are cut off, but it's page 8, subsection 2. So this is the dispensing, and here's the problem we're about to face with dispensing. Is in 324, we by law, these companies, these 6 licensee holders, they have 12 months from the time they get their license to the time they have to put medicine on the shelf. So think about that, 12 months and some of these applicants are going to have to build a building, then grow, manufacture, produce, extract the oil, and produce a product, and then they're going to have to get it on a shelf in 12 months. Now, the building of the building is going to take somewhere between 7, 8, 9 months. So really, they're only going to have about 3 months to do this. Here's the problem we have. We don't have any shelves. In 324, we never set up any form of dispensing. So there is literally 0 shelves to put it on. And by law, they have 12 months, and these licenses are going to be issued sometime in the next 1, 2, 3 months. So you're talking about 13 to 15 months that we have to have a shelf for them to put this on. And right now, there literally is, we didn't do it. We ran out of time, thought maybe the pharmacies would come forward. They haven't done it. So that's what we're doing. We have to figure out a way. And so I've come up with it's a concept. And what I did was I took the state service delivery regions. There's 12 of them in this state. Y'all should have a map in your folders that looks like this. It shows the 12 regions. What we've done is saying each licensee, each of the 6 will get 2 dispensing permits or licenses, whatever we're calling them. They're going to get 2 each, 2 dispensaries. And you're only going to have 1 in each region. So that's 12 dispensaries in the entire state. And we're spacing them out. And because obviously Atlanta area, which is in Region 3, is going to be, more desirable than probably, down in Region 10, down in Senator Burke's neck of the woods. What we've decided to do is auction them off. And this isn't some new concept. It's something, if those of you that have sat on regulated industries and you're familiar with COAMs, and you're familiar with master licenses, we actually, the lottery auctions off master licenses, and that's actually where I got the idea from, to do it this way. But we're not setting a new precedent in state government, but what we're going to do is auction off each region until all 12 regions are gone and there's 12 dispensaries. Now, full disclosure, if you look at subsection 3, the commission may also issue 4 additional non-transferable retail dispensing licenses. I have to admit, that was in my original sub, and it was not supposed to be in the final sub, and I didn't catch it till about 2:30 today. And in full transparency, I didn't feel right introducing a new sub.
Page 8, 191 through 193.
Correct.
You wanted to strike that, I guess?
I did want to strike that.
Okay.
So I did not want that in.
All right.
And then also, and finally, on page 10, since we're auctioning off, if you look at lines 224 through 228, if we're going to auction them off, I don't feel like we need to have an application fee. So really, lines 224 through 228 should come out as well if we're going to go with this current concept. Okay. So that's pretty much what it does.
Any questions from the Senator Jackson?
Yes, sir, Mr. Chairman. Hey, Mr. Chairman, I'd like to refer you to page 6. Go back again when you talked about the University of Georgia and Fort Dallas.
Sure. So right now by law, it says the commission shall issue non-transferable designated university licenses for the production of low THC oil. So we force the commission, we are saying the commission, you are going to issue 2 licenses to the university system. Because they haven't come forward yet and said they wanted these licenses. Of course, we haven't issued any at all, and we're 2 years down the road, but they may never come forward, they may never want them, so we're just simply taking away the shall and saying that if they come forward and they do want that license, then the commission has to issue that.
Upon request, I got you.
Upon request, exactly.
Okay, thank you.
And just to kind of refresh you back on HB 324, and for our new members, what that license was a partnership between one of those 2 universities and a private company, to where they would come together, they could produce oil, they could research it, and then any oil that was produced or any product that was produced out of that would then be returned to the commission. We never really said what the commission would do with it, but that's the way that process would work, and that license.
Follow-up question?
Yes, sir.
So then the commission would have the right to give that license to another entity?
Negative. That's not the intent.
But they could?
Show me where you see that.
Well, it says, upon request, the commission shall issue a non-referable license, all right? But you're saying if they don't come forward, they have the license, that the commission will have the license to issue it to another entity?
No, that's inaccurate.
I don't think so. Senator Kirkpatrick.
I have a question and then an amendment. But the question is, the lines you're referring to on the top of like 224 to 228, what happened to the pharmacists? Why do the pharmacists not want to be involved with the process? Because if they did, then we wouldn't need these dispensaries, period, right?
That's accurate, yes. And there's, with marijuana still being in Schedule 1, I think there's a lot of them that are scared to to risk putting their license at risk. And so I would like to leave them available should marijuana ever come out of Schedule 1. I feel like the pharmacies, independent pharmacies, would jump all over this opportunity.
So really, you don't want to delete those lines then, right? Because you still want to give the pharmacist.
I want them to have the option, yes. And so if you're familiar with the term vertical integration, and y'all probably heard that, what this bill does is it takes us to, as long as the pharmacies stay out of it, we're fully vertically integrated, meaning the same company is growing, producing, and selling the oils and products. So we are fully vertically integrated. And I'll add this too, that states where vertical integration is still there, those are the states that have maintained medical marijuana only and have not gone to recreational. It's the ones that have went to the more of a horizontal, meaning they had individual retail licenses that had no connection with the grow or manufacturing. Those are the states that typically went to recreational. However, with coming out of the study committee we did 3 years ago now, we actually made the recommendation to go to more of a hybrid model. And honestly, what I think, if we stay vertical, and then one day if the pharmacies come in, that falls in line with our recommendation of it is a hybrid model. But to me, it keeps us away from going down the path of recreational, and you don't have dispensaries popping up on every corner.
And Senator Kirkpatrick, you had an amendment there?
Yes, and I didn't copy it for everybody because we've already passed it once when the bill came through the first time. But basically, it goes back to page 5 to line, so on line 104, it would say and then on line 105, it would say to review in consultation with physicians licensed under Chapter 34 of Title 33. And then on the next line, line 106, it would say may result from medical and clinical research. And then on line 251, you've already mentioned this one, changing the Oversight Committee shall rather than may.
Yes, I'm good with all those, and
Okay.
I think you're.
Yes, while we're at it, if you don't mind, can we go ahead and make your amendments to, if that's okay with
James has it,
Arthur?
so, yeah. However you want to do it, Mr. Chair.
So we're striking lines 224 through 228. And
I don't think, I thought we weren't going to strike that.
Did you decide not to? Well, let's do it separately then. Let's go with your amendment, looking for a second. Second, Senator Burke. All those in favor of Senator Kirkpatrick's amendment, say aye.
Aye.
All those opposed, like sign. Okay, so do we have any other amendments or suggestions? And we'll follow through with an amendment there, Senator
So
Bryce.
I think Senator Kirkpatrick was right. 224 through 228 did need to stay because that applied
Okay.
specifically to the Board of
All right.
Pharmacy.
But you were talking about 191 through 193.
Yes. I was looking in
Page
on
8.
Page 8.
Page 8.
Yes, 191 through 193. I would accept I would love a friendly amendment to
I will
remove
make
that.
the motion to delete lines 191 through 193. Second, Senator Burke. All those in favor say aye.
Aye.
All those opposed, like sign. Passes unanimously. Well, I'm in a posture. Let's see if there are any other. All right, Senator Burke, all right, I'm sorry.
Yeah, I misspoke on that. That's dealing specifically with the pharmacies, and I just misread it. I think that's better. I was thinking that was more dealing with the dispensaries, but we're auctioning those off, so we're okay there.
Okay. Any other discussion or questions, Ms.?
That 228 is actually the Commission and the State Board of Pharmacy, so it's both their dispensary licenses.
So then we would probably need to strike after.
Commission and the, so it's the State Board of Education, Pharmacy rather, shall, and
We're carving out the retail, the
Okay.
the
Can we,
licensees.
can we restate that again, Ms. Howerton?
Yeah, so we would read the State Board of Pharmacy shall be authorized by rules and regulations to require its applicants for retail dispensing license to submit.
Okay, I got it. Does everybody understand that? Senator Cowsert?
I just want to be heard for discussion before you take the vote.
I will.
Know where you were yet.
So we'd have a second on the amendment there. Ms. Howerton? The state, yes, we're striking out the commission. Right. Have a second on that? I'll second it. All those in favor say aye. All opposed, like sign. Okay, unanimous. All right, we're still in the discussion mode. Senator Cowsert?
I just want to say.
Let me turn you on. Okay. Okay.
My life, okay. You know, as the senator started his discussion, they made only a couple of changes to our version that we voted down 8-2 last week. This is a 30-page alleged cleanup bill, which is a major restructuring of our medical marijuana system. And I'll just, because it came through regulated industries last year and we chaired it and I was on the conference committee as we went through this, it's important to realize what we were trying to accomplish. We had all these children that were having medical conditions that were of the opinion that cannabidiol oil type products, THC oil, were helpful. So far, there's been one approved by the FDA. And one reason there's only one approved by the FDA is because it's a Schedule I drug. It is still illegal nationally to possess it. You're violating federal law, even if you're in our little scheme of licenses, distribution, et cetera, universities. There's one exception for that, and that's if you receive a license from the National Institute of Drug Abuse. And that's a federally granted license that can be given to research institutions, land grant research institutions, like Ole Miss, which has a facility there where they grow it. You can do it legally within their confines, and that's who ought to be researching these products to help these children get new products to the market. We crafted our bill, and this totally takes it away. You'll see on page 7, section 4 is a deletion of the paragraph that was titled 1612-205 that dealt with the role of Georgia's universities, which said the university system shall apply for this NETA license so that they could participate in research, get federal research dollars, and let's find products that will help these children and other people with ailments that can be helped by THC oil products. This was crafted to get participation of the majority and minority party because, as it turns out, our only two land-grant universities are the University of Georgia and Fort Valley State University. They are now cut out of the deal here. Now, any university that partners with one of these 6 fortunate licensees will be able to do research only if they partner and only if granted by this commission. But they're not going to be able to do it because the University System of Georgia is not going to allow their people to violate federal law. And only 2 of them can get this license from, we call it NIDA. So it's going to end up allowing some private colleges to partner if their trustees are risk takers enough to partner with these licensees. That is a major difference. We were trying to get to the research. We also, because of that, had Board of Pharmacy involved. This is a medicine. We wanted them to jointly develop these rules and regulations, and that, by the way, is stricken on line 8 from jointly adopting rules relating to this dispensing to separately adopting those rules. So this is a power play by the commission where they can now control the licensing process, push the pharmacies aside. We wanted pharmacies. We were doing this for medical marijuana, supposedly, if you recall. They haven't issued any license to pharmacies. They hadn't issued a license to a production person yet. Took a year for the commission to get appointed. They only recently got their application process developed and took applications. There are 70 businesses that want these licenses, and there's only 6 of these retail licenses they're giving out. Now they're saying they want to let those people, instead of pharmacies, have their special pharmacy license and other retail licenses.
We called for the board for their joint process to ensure that retail outlets are dispersed throughout the state for access by registered patients. We were trying to give them access. Now we're auctioning these dispensing licenses to who's got the most money. What big corporation's gonna outbid the smaller people? We're gonna concentrate who can sell it. We also intentionally tried not to have vertically integrated distribution systems. I beg to differ. I think that is the model, the business model, if you want to have recreational marijuana. You want to grow it, you want to make your product, and you want to sell it at your own branded retail outlet. This gives you the, not just the ability, but the right to do that. Y'all need to be very careful. Man, if this passes, I'll probably be on the floor passing offering an amendment. Let's just go ahead and say we are going to legalize recreational marijuana because it is the roadmap that's used nationally to do that. And let's just go ahead and get to the end game if that's where we're trying to get to here. We're in the very early stages, haven't even given one production license yet, don't even have the rules and regulations jointly developed for the retail outlets and the dispensaries, but we're trying to come back here and revamp and give more power. And to kick it off on that, oh, well, there's too many churches in South Georgia, so let's take away the distance restrictions here of 1,000 feet where they're prohibited from building these warehouse, greenhouses where you're growing the pot, next to schools with your children, next to churches where you worship. We're abolishing these restrictions that we put in the bill to start with. I've got so many notes here of things that are different, that are contrary to what the Senate position was. And even the conference committee report came out so one-sided to the House side on this, on the prevalence of making marijuana available, that I didn't sign the conference committee report. So we're now backing off from that. The surety. We required these licensed one people to have $1.5 million cash bond. And we required $650,000 or $625,000 cash bond for Class 2. This abolishes that. It says now, or other comparable surety, as determined by the commission. I just raised the warning. There's a reason we voted no the other day on this serious of a bill, and I'm a strong no again today, and I encourage you to think carefully before you agree to this early in the process, when this commission is barely even up and running and now asking to take over complete control and give it to these producers.
Thank you, Senator Counselor.
One last point. We didn't set it up that they would be making the products also. These licensees are supposed to grow marijuana and create the oil from which the products would be made. We reference all kind of subcontractors and things in this bill. In fact, we had minority set-asides for some of these contractors. Well, there ain't gonna be subcontractors now if the grower is also the product maker and the seller at the end of the game. So I just beg you to
understand.
Be careful what you do.
Senator Kirkpatrick.
I just got a little feedback from the pharmacies that I'd like to share.
Sure.
Put you at that subsection.
They have 2 points. There are pharmacies that would do this, but they're waiting for the Board of Pharmacy to promulgate rules and regs. The Board of Pharmacy is beginning work on those rules, and they've been in discussion with the board in that regard. And then the second point is, while some pharmacies are willing, others would be hesitant in light of federal law, as pharmacies have DEA numbers and payer agreements contain provisions that pharmacies will not violate federal law, and I think you alluded to that.
Yes, ma'am.
All right.
Thank you.
Thank you. Senator, yes, Senator Warren.
The hour really is late. I don't know what states are doing it the way that Mississippi is doing it, because that is a pathway to access a federal process and kind of sidestep.
I'm not sure now. At the time we passed this 2 years ago, there were 13 other states that had made that NIDA application. I don't know which have been granted any yet.
That's a very.
I don't know how many, but I know we passed this, like the senator alluded to, 2 years ago. and they have not applied for the NIDA grant, which we said they shall apply for the NIDA grant, and 2 years later, they have not
being
applied
the
for the
commission?
NIDA grant.
They-
No, the university
Oh.
has not applied for the NIDA. They haven't started the process that I'm aware of. They have not applied for it. It's been 2 years. I think can I close? You want me to close? Or?
If you, please.
So, I think it's interesting that the senator brought up some great points. Senator Cowser brought up some great points. Some of it, I think he just flat out made up, because I totally don't
Let's
agree
be
with it.
respectful.
And I'm trying to be. And we talked about bringing medicine to children, and we've literally given no way to do that. All we've done is allow this state to produce the medicine. We have no way to put the medicine in their hands. And that's all this bill, that's one of the main parts of this bill of what we're trying to do is get the medicine on a shelf, which by law they have to do in 12 months from getting a license, and literally there are 0 shelves. I can't say that enough.
It hasn't happened. I got you. All right, so I'm the will of the committee here. I will entertain a motion. Do we have a motion on this bill, which was House Bill 645? Getting a lot of cold stares here. All right, got a motion, do not pass. Have a second. Any further discussion? All right, we're going to vote that. All right, all those in favor of this motion of do not pass for House Bill 645, raise your hand. 1, 2, 3, 4, 5, 6. Is that right, Mr. Peel? All right, all those, so I guess all those against that motion. We got 1, 2, 3. All right. The motion passes of do not pass, and that bill is dead. Thank you. Thank you. Listen, I appreciate your patience. I apologize for the late time, but I think that keeps us from coming here in the morning to get that bill done. Although it may have been better done in the morning, might have been a little bit less irritable on a more full stomach, but I certainly understand. Meeting adjourned.